Hi everyone, I welcome you back to our channel. This is Legal Mindset at the bar, and today we are going in for constitutional history. We are going to look at one of the most core topics, the question of ex-parte Matovu. What happened in that case? What fundamental legal principles were laid down? And as a bonus at the end, we shall take you through a question. A question many colleagues ask themselves, that the Ghost of Ex-parte Matovu was laid to rest by the enactment of the 1995 Constitution. And with me here, I'm with a learning colleague, very good at constitutional history, and it is a good source. She's one of the sources I know you can understand this topic from. I believe by the end, you will be good to go. Touch that subscription button. We move together. We are in the period of exams. Council Estella, thank you for honoring our invitation. I beg you introduce yourself to our viewers.
I'm by the names of Stella Peace, a learning friend. Thank you so much for the invitation, colleague. Today we are here to dissect something very important in the constitutional history of Uganda. And basically we shall be looking at the Commissioner of Prisons, Ex-parte Matovu. And as my colleague has already talked about, the question that is always being asked, that the Ex-parte Matovu's ghost was finally laid to rest by the promulgation of the 1995 Constitution. And here we are to help you on how to approach such a question. Yeah, thank you so much.
Thank you very much. We had already recorded this video on our channel, though it was not so conclusive to the extent of reaching that question. So I beg you take our colleagues of the key incidents that took place. How did he become called Ex-parte Matovu? How was the arrest? Why was he arrested? Under which laws was he arrested? So let us begin, Council. You start to dissect it for us.
Thank you so much. Looking at the Ex-parte Matovu, we all need to note that Ex-parte Matovu was a Saza chief. I hope if you've tried to read this case, it is an interesting one. And then those that have not tried to read it, I would encourage you to go and sit down by yourself and read it before I tell you something today interesting. So in the case of Ex-parte Matovu, you need to know that Ex-parte Matovu was a Saza chief. And him being a Saza chief, it means that he was a very important person in Buganda Kingdom. We need to note that ex-parte means on one side. How does the name Commissioner of Prisons come about? Let us begin from there. As my brother has already told you that ex-parte was arrested on the day prior to the enactment of the detention laws that were put in place by His Excellency Obote. I hope you've all read the Obote regime of 1966. It is the regime in which Ex-parte Matovu was arrested. And we need to understand one thing, that when Ex-parte Matovu was arrested, he was arrested in one prison, and then he was later on, having realized that he was spreading a lot of propaganda among his fellow prisoners and influencing them to hate the current president, and that is His Excellency Obote. He was transferred from one prison where he was and then transferred to Luzira, where he had to serve until the court hearing. Well, Ex-parte was taken to Luzira. It is important to know that this guy was very influential. We know influential people in our country. He was very, very influential in the making. So when he was taken to Luzira, he reached there and he continued with his propaganda of letting these people know that Obote was not the right president for them. And the fact that he had brought the detention laws into enactment, it was not something right, and he was conquering with it. He wasn't at all at any one point. So he requested that prisoners join him in making sure that they do not accept such kind of government. Since even the way Obote came into his governance, it was not the proper way that people are supposed to follow to ensure that the government is put into place. Let us all be let us all be made aware of this, that our president Obote came into power through a dictator. So Matovu was not happy with the dictator, that this guy was not supposed to be their president. And then looking at the fact that he brought into enactment the detention laws on which he was held accountable before their enactment, it was also a question that was brought up. So the fact that all prisoners listened to him, he was even transferred from one prison to another, it made him a commissioner of prisons. And then why does he become ex-parte? At the time when Matovu's case was supposed to be heard before the courts of law, Matovu was not available. Even his own family could not trace for his whereabouts. His case was listened to. In other words, the writ of habeas corpus was not put into consideration. My dear friends, we've put along a question at the beginning. My colleague put a question before us that would guide us on how can we reach out to such a question. If they told you that the case, the Commissioner of Prisons, Ex-parte Matovu's ghost, was finally laid to rest by the promulgation of the 1995 Constitution, how do we go about that? Basically, you're going to start with the facts of this case. My brothers and sisters, they are learning friends. Trust me, you cannot attempt the question if you don't know the facts of the case. So you're going to start with the brief facts of the case and let people know that you know what you're talking about. And then from the brief facts of the case, you're going to proceed to the legal issues. Which legal issues are supposed to help you in dissecting the different issues that were very important, key matters that were talked about in this case of Ex-parte Matovu. There were 4 issues that were raised. And basically, the first issue was whether Ex-parte Matovu was denied the writ of habeas corpus. Then secondly, whether the detention of Ex-parte Matovu under the emergency laws was legal. Thirdly, it was about the political question doctrine. And then lastly, they looked at whether the enactment of the 1966 Constitution was valid. My dear friends, colleagues, we need to understand the 4 important issues because they are very important while you're dissecting such a question. First of all, we shall start answering one question by one. And then I will start with the political question doctrine. It is important to note that this case of Ex-parte Matovu established the independence of the judiciary. Remember, we have 3 arms of the government, where each arm is not supposed to interfere with the arms of the other. We have the executive, the judiciary, and then the legislature. We need to know that this particular case of Ex-parte Matovu put in front of us the fact that the judiciary is very independent, meaning it stands on its own and it never interferes with the works of the executive. So the political question doctrine, in other words, it was looking at remember in the legal issues, it was questioning as to whether the laws that were put into place were legal, and even the 1966 Constitution, then the government itself, whether it was legal.
Yeah.
My dear colleagues, I want us to understand something. The fact that the judiciary is independent, very interesting of this case. They did not tamper with such a question. How the court responded to this question, they simply said it is a political question that we cannot answer. So this meant that they could not say anything about the legality of the government, about the legality of the Constitution, about the legality of the detention laws that were put into place by the president. Secondly, we need to look at the writ habeas corpus. Very interesting to know. Our article currently, our constitution currently,
44.
under Article 44D, it stipulates and makes it very clear that a writ habeas corpus is a non-derogable right. There are only
Absolute.
4 non-derogable rights. No one can derive away those rights from you. They are your rights, and they're not supposed to be tampered with. Interestingly, the writ habeas corpus was not available by the time when it was there, but then looking at our brother ex-parte, he was nowhere to be seen before the courts of law. It was very clear to everyone. You know, they said the law is not fair, but it is just. It was very clear that ex-parte was not before the courts of law. So this meant that his writ habeas corpus was indeed not granted to him, and that was an issue dissolved like that. Interestingly, we are left with 2 issues to handle that are very important, that are going to lead us to the exact gist of our discussion today. When we look at the 2 issues, one was whether the 1966 constitution was legal, and then secondly, whether the detention and emergency laws that were enforced under which ex-parte Matovu was arrested were also legal. My dear colleagues, I need us to put this into our minds. I don't want us to cram these things. I want them to flow within your blood as a person who really understood the law. I want us to take note that there is something called the Kelsen's theory. Under the Kelsen's theory, this guy is very interesting. Even right from UK, they use him as an example. When you look at Marlborough's case, they talk about these things, about the Kelsen's theory. It is a theory that gives us the principle on which these laws, these legal issues that were put across, it is an answer to these 2 questions that were put across before the courts of law.
For me, I call it the Hans Kelsen theory of revolutionary legality.
Oh my God.
It determined it very well.
You people, I don't know if you find this interesting as we do, but then, as my brothers told you, he even gave it a special name because the theory itself is quite interesting.
Yeah.
So when we look at the Hans Kelsen theory, under this theory, there are 3 things that we need to note. One, we know that a constitution in our country, Uganda, it is the supreme law, as per Article 2 of the Constitution of 1995. It stipulates and says that the Constitution is a supreme law, where all other laws derive their authority from. Any authority, any law that is inconsistent with the Constitution is therefore rendered null and void ab initio. So, therefore, the Hans Kelsen's theory tells us that the 1995 Constitution was, by then it was the 1966 Constitution, that this Constitution was a very superior thing. But then we need to note something, that under Hans Kelsen's theory, he told us that when there is a proper procedure in which a government is supposed to come into force. But then if that government comes into force through illegal ways, they have to find a way of legalizing their government. In case they came into enactment through a dita, we all know what a dita means. In case the government came into force through a dita, that means it is an illegal way. So this means this government has to find ways of making sure that this government is legalized and recognized by the people. My dear colleagues, I want us to take note that under this, we need to understand these things. If a government comes into force and it is illegally, they either remove the constitution as a supreme law, and then they render it null and void according to them. Then secondly, they could either bring into force a new constitution that they feel like it's going to help them in governing the country. Or they can go ahead and pick out a given article under the constitution and use it to legalize their what? Their government. Very wise of Obote as a president. This guy knew about all these things. I want to let you know. When he came into power, before he first rendered the current constitution null and void. Oh my God. I don't know how this guy was very wise,
Yeah.
but he first rendered the constitution null and void, meaning there's nothing to control the country. And then he went ahead in that very constitution that he rendered null and void and picked out the detention laws, the emergency and detention laws. Now, these emergency and detention laws, he got them and made them make his government legal and recognized by the people. My dear colleagues, I don't know if we are all at the same page, but I believe you're understanding what I'm saying. He legalized his government through an article in the constitution which was talking about the detention and emergency laws. Which detention and emergency laws was something that was really disturbing Ex-parte Matovu. In his brain, he was like, because the laws were supposed to be enacted like the following day, for him, he was arrested like today. But then that was not important. The fact that they had been talked about and he was aware of them, he could still be held liable over them. For the 1966 Constitution, for it to come into force and be recognized as a constitution, we need to understand that this constitution was not legal. But then the president that we had by then, Obote, ensured that that this constitution is put into enactment. So it is important to know that under the Hans Kelsen's theory, they tell us that if there are two fighters and they are very strong, let's say my colleague here is our commander, and then I am just a subordinate, and we go for a battle. If we reach at that battle and then, you know, as a commander, we expect you to be very strong and energetic.
Indeed.
If we reach at the command at the battlefront, and then he's shot dead, imagine the one we consider superior is shot dead. That means that
you get demoralized.
Exactly, the commander. It means the commander was weak. Now me, in that battle, if I'm not killed, it will mean I'm actually more superior than my boss, and that means I can be recognized as the superior compared to my boss. The fact that I've gone to the battle and come back alive. This is what happened to the constitution. They removed the constitution, but however, this guy went ahead to pick up a certain article which talked about the emergency and detention laws, and it made these detention laws to be more superior than even the constitution at that time. Important to note. This is very important to note.
Also,
yes, please.
It means that Ex-parte Matovu was detained under the emergency and the
detention laws. Yes.
So, him, because for him, he argued that according to the constitution, what he called the constitution was the 1962 constitution. He was innocent. So it means Obote outsmarted him.
Very true.
Thank you very much. For me, I've been following and I got what you're trying to mean.
How I wish all our followers are doing the same. Well, I said this one is important to note. Remember, we are trying to answer a question. I don't want us to forget that we have said, let us start with the brief facts. Under the brief facts, you know what it means, brief facts.
Yeah.
We are saying his detention, his transfer from one prison to another.
The most relevant facts.
Exactly. The most relevant facts is what we are going to bring under the brief facts. From there, we are going to bring out the 4 legal issues that were stated under the case of Ex-parte Matovu. And then after stipulating down our 4 legal issues, we are going to go ahead and then start resolving issue by issue. Talk about the political question doctrine, talk about
even question the legality of the government.
Exactly. Talk about the habeas corpus, talk about all those things, talk about them in detail, just like a law student would do. So this is what I'm saying that is important to note. Now, our guest of the discussion today is under Article 3 of the current Constitution of Uganda today. Article 3, Clause 3. When we look at the ambiguities in all the previous constitutions that we used to have, they were really alarming, dear.
Okay, I'm sorry, but they missed out some things.
Very.
Yeah, as if they had planned that let coups come in.
Actually, the detention laws, as my brother said, it was making it very clear that, you know what, people can actually come and overthrow the government.
Yeah.
It was okay for the coups to happen. But then, this is why you see, after Obote, we had Amin overthrowing him, we had the Tito Okello Lutwa, we had the, oh my God, mention all of them. You know, all those coups that we had.
One weakness can cost so much.
Exactly. So like this was a weakness that needed to be identified and then washed away by the current constitution that was supposed to be enacted of currently that we are having. The 1995 constitution tells us under Article 2 that it is the supreme law where all laws derive their authority from. Do not forget that. But then Article 3 provides for the defense of this constitution. Back then, the constitution did not have any defense, and we saw the coup is coming up. So now here, I don't know, oh my God, who came up with this constitution. The person is very wise.
Actually, before those amendments, the age limit, it was ranked one of the very best constitutions in the world.
You get? But it is a very interesting one.
Now that we are against it, let us not go more politic. Let us continue with our discussion.
I understand.
Yes.
You might be here and some of you are against the political parties that are around. Anyway, we put that aside. They went ahead to provide for an article that talks about the defense of our constitution. Basically, when you look at Clause 3, it stipulates for us the defense of the constitution, and it says in case anyone raises up any single day and tampers with the constitution, at the end of it all, when the wars have ceased to exist, this person is going to be held accountable by this very constitution that he tampered with. Yeah. So in case you come as a president, yes, you have your right to come and put into force your own constitution. You can put on a law that is making sure that your government is legalized. But however, once you step out of power, do not forget you're going to be held accountable by Article 3, Clause 3 of this very constitution. So we need to make sure that we know what Article 3, Clause 3 talks about, because it is the main gist. Yeah. Exactly, it is the main gist of our discussion in this entire case. So Article 3 is an article that made sure people could not enforce any more coups. People could not come up with any laws anyhow just because they want their governments to be recognized. Yes. People cannot underlook the supreme law of our dearest country. They have to respect it. You get? Very interesting something. So Article 3 is the main gist of our discussion today. As you're done discussing about the brief facts, the legal issues, you've dissected every legal issue in the manner that you understand it best according to the case, how you read it. Come and talk about Article 3, which is very important to our discussion.
Because Article 3 answers all the questions of Ex-parte Matovu. Because we see the question where I said that the government was illegal. Means Article 3 said that anyone who comes with force to alter this constitution, at the end, they will be liable. But remember, the 1962 never provided for such.
Very true.
So, he was not liable about the man who overthrew it. But for this one, do not temper. As Article 3, Clause 3 states. So, in fact, if it was the constitution in place, Ex-parte Matovu's questions perhaps would have been correct.
And then we need to understand something very small, that under our constitution, it is important to note that this constitution is something very superior that everyone believes in. As my brother has told me, by the time Ex-parte Matovu was arrested, these were kind of dissatisfactions that he was putting across as any other normal man who doesn't know about these things.
The constitution is never covered for it.
This current constitution that we have, oh my God, it came up to answer all the questions that this guy had in his, that he put across before the courts of law. Why didn't you do this? Why didn't you do this? Trust me, right now we cannot even trace for Ex-parte Matovu's whereabouts. We don't know whether he passed on while he was in Luzira, but then I'm pretty sure wherever he is, his ghost was indeed laid to rest.
Yeah.
Because if your questions are all answered, that means you don't have any kind of dissatisfaction with you. It means that you've actually been given all that you were asking for. So wherever he is, whether he's still alive, we might be here when this nigga is still alive.
Somewhere there in the seeing us. So the 1995 constitution, at a certain extent, pointed out all his questions and borrowed his idea. But however, the independence constitution we got, I'm sorry, but it was somehow lame. So it never covered for some things.
Very true.
Which he questioned as a person, but he could not be favored. So, and as if the Article 3 of the 1995 Constitution is somehow contradicting with the Hans Kelsen theory of revolutionary legality.
Sure.
Because for it says that if you try to tamper with the Constitution, it shall work upon me if it comes again in force. So, give them a remark, Council. Indeed, the discussion was so great.
As I come to the conclusion, it is a pleasure once again to be invited to this channel. We need to understand that after handling all that, trust me, you will have captured the lecturer's mind, and then he or she will give you all the marks you're looking for. Just go ahead and put a conclusion to whatever you have discussed, and then they can also put for you a question to give the implications of the 1995 Constitution in regards to the case of Ex-parte Matovu.
Maybe we can see some cases which were influenced by that case. The political question doctrine, we see it in Major General David Tinyefunza versus AG, where Justice Kanye Amba said that some aspects of the executive are political in nature,
that
the judiciary shall not interfere in them. Actually, the case also respected the doctrine of separation of powers, and indeed it is a landmark case, both in the history and it has shaped the present. So you're not only going to find it in 1-1, you're going to find it in other years. This is a case a number of constitutional lawyers have to hear. If you want to become a good constitutional lawyer, appreciate this case. So I thank you very much, Council.
Thank you so much.
Because up to now you still have this content of it, but you read it long time back. So thank you for. I can't thank for the brain. I know you're a person of reading books, the libraries. Last month I found that the university library there at but what we should do is that you tell those students to subscribe to our channel, to turn on the notifications, because if they don't turn off, if they don't turn on the notifications, they may not see us again.
And you people, comment on the videos, please. Kindly comment on the videos. Let us know where to put right, what to talk about. Maybe next time you might be interested about in something that we've not covered. My colleague could have not talked about it, but then there is no way he's going to know if you don't give him feedback. Through the comments, you enable him to serve you very well. So kindly subscribe to the channel, share, like, comment, and advise others to do the same. Thank you so much.
Thank you so much. This is Legal Mindset at the bar.